This talk is going to be on the judicial interpretation of standard setting. Now, we've gone through the influence of the executive branches of government, the legislative branches of government, and we're going to focus on the judicial branch of government today. And we've gone through how OSHA was set up and how the Review Commission works. And if you have a case that goes outside of the Review Commission, it's going to end up in the federal courts. And this is going to be some cases that have undergone judicial review on the standard setting process that OSHA currently does. If you've ever read an OSHA standard when it comes out in the Federal Register, it's a very lengthy document. I have a copy of the cadmium standard here in my office, and it's about 500 pages long, which is in the Federal Register document. This is tiny print, 3 columns per page, and it includes a lot of information. And you ask yourself the question, why does OSHA put so much information in when it's setting a standard? Well, it's because of the cases we're going to be talking about. And what these cases have done, and these are some early cases, they really give some directions on what OSHA has to do if they're going to establish a standard through the 6B process and have it stand up in court. And a couple of these are very exemplary of the process: the asbestos case, the vinyl chloride case, the coke oven case, and the benzene case. These aren't the only ones or the only times OSHA's been in the court system, but it does give you an idea of the methodology OSHA has to use to set standards based upon what occurred in these particular cases. The first one I want to talk about is the asbestos case. Now, I've got a link up there to the asbestos case, and it's a district court case, and this was OSHA's promulgation of a permanent asbestos standard. This was the Industrial Union Department versus the AFL-CIO. Now, this case dealt with OSHA coming up with an asbestos standard. Now, this is one of the earliest standards that OSHA had promulgated. And once they had done this, and it lowered the level of asbestos exposure, and the actual facts of the standard aren't as important as what the courts ended up addressing. But again, this was when the agency was brand new and they were right off the blocks, and there were some certain reasons that they were sued when they promulgated this first asbestos standard. And what the courts looked at in specifics was the couple of things. The substantial evidence test. We talked about that earlier on a substantial evidence test versus something that's arbitrary or capricious, and this was addressed in this particular case. The weight that's given to NIOSH recommendations, and what the word feasibility means under the OSHA Act. So these are the 3 major areas that help give the agency direction based upon this particular ruling on asbestos and what the court decided. The substantial evidence provision states the following: that the determinations of the Secretary shall be considered conclusive if supported by substantial evidence in the record as a whole. Now the problem here was what we talked about earlier, the hybrid nature of OSHA rulemaking. The formal OSHA Act and the Senate wanted OSHA to follow an informal rulemaking process, and the House wanted formal rulemaking with substantial evidence review. Because this was in the legislative history of the OSHA Act, the Secretary at the time thought that this may be fairly problematic when OSHA ultimately is challenged in court, and so it came up with a hybrid method of making its rule. And what this did is it went above what Congress directed it to do. The Secretary directed that the following: a qualified hearing examiner should preside over the oral hearing, cross-examination should be permitted, a verbatim transcript made, and the total record should be created by both the formal model and the informal, which included both the above from the formal model, the cross-examination, verbatim transcript, etc., and the informal components, which are the written statements, the letters, reports, etc. So essentially, Congress did not tell OSHA that it had to go through this process. It had to follow 6B, but the Secretary decided that they would do more than what 6B actually required them to do by going through both a hybrid model that includes elements of both the formal and the informal. And The courts, when they reviewed this information, basically said, well, Congress has authorized the Secretary to make specific standards. And we believe that this is a good process that they're utilizing. And what they've done is give every interested party an opportunity to be involved in the process. And once they've done that, they're like a congressman casting a vote. Therefore, what happens when congressmen cast a vote is that they talk to a lot of different constituencies, and some people will say vote this way, and some will say vote that way, and they basically make their decision on what they think is best overall for the constituencies. And OSHA is authorized to do that by the OSHA Act. The Secretary is allowed to make these type of determinations. This is a policy decision. The Secretary is authorized to make them, and provided that they have given all interested individuals an opportunity to participate in the process, the courts ruled that what they did was fine. So they were okay on the substantial evidence portion. The next portion of the case dealt with NIOSH recommendations. And the reason that this occurred was that the petitioners said, wait a minute, NIOSH had recommended a lower level of asbestos exposure than OSHA came up with. And they ignored what NIOSH said. So the court then had to determine, okay, what weight do NIOSH recommendations have when OSHA is promulgating a standard? Well, what the court did is look at what the OSHA Act authorized NIOSH to do and what Congress authorized OSHA to do. And what NIOSH is authorized to do is represented in this slide, that the Secretary of Health and Human Services, on the basis of such research, demonstrations, and experiments, and any other information available to him, shall develop criteria dealing with toxic materials and harmful physical agents and substances, which will describe, and I underline this, exposure levels that are safe for various periods of employment, including, but not limited to, exposure levels at which, underline again, no employee will suffer impaired health or functional capacities or diminished life expectancy as a result of his work experience. Then the court looked at what OSHA was authorized to do by Congress. And if you read through that, it's very similar except for the areas that I have underlined, which is to standard which most adequately assures, to the extent feasible, that no employee will suffer material impairment of health. Now note the differences. OSHA has to deal with the issue of feasibility and making sure that no employee will suffer material impairment of health. What NIOSH has to do is look at exposure levels that are safe. No, there's no mention of feasibility that has to be done by NIOSH recommendations, and that no employee will suffer impaired health or functional capacity. So the main difference between the two is OSHA does not have to take into account feasibility considerations, and these are generally economic or technical feasibilities, as we'll discuss in a couple of the other cases. NIOSH doesn't have to do that, and NIOSH tries to set a level that no employee will suffer impaired health. Whereas with OSHA, it's material impairment of health. So there's a little bit of a difference. Let me give you an example of how this became an issue. Years ago, when OSHA started getting into the biological world, it came up with the bloodborne pathogen standard, and it was starting to get into an area of really medical care by coming up with the tuberculosis standard. And when OSHA was in the process of trying to come up with the tuberculosis standard, the first thing they did was have a NIOSH recommendation, and NIOSH came up with a recommendation. But the NIOSH recommendation was based upon the type of information that's listed here and what Congress authorized it to do. Well, tuberculosis, that's an airborne bacteria. And if you are exposed to an airborne bacteria and you inhale one of those and it gets inside of your lungs, one of those bacteria could potentially multiply in your lungs and give you the full-blown disease. It's kind of like, as I'm giving this lecture right now, we're having an Ebola concern in the U.S., and if you ask the question of what level of an Ebola virus is safe, you would have to say none, that one virus could potentially infect a person and be dangerous. Well, that's the approach that NIOSH recommended with tuberculosis, that there was no safe exposure level. And so the only way that you could make sure that people who potentially were exposed to tuberculosis were to put them in level A suits. Well, the healthcare community has been dealing with sick people for years, and there's processes in place that physicians and nurses have for dealing with infectious patients, and they are not necessarily having them go into level A suits and and causing a lot of uncertainty and fear within the patient community. So when OSHA was trying to come up with a standard for tuberculosis, their original standard incorporated some elements of the NIOSH recommendations, which said anybody that comes into contact with a person with TB should wear a level A suit. Well, the healthcare community was very unhappy with this, and ultimately there was a compromise that OSHA did not promulgate a standard, but came up with recommendations on tuberculosis, which would be wearing an N95, kind of one of those dust masks. But the trouble that they got into on that is the differences between what NIOSH does and what OSHA does. And again, NIOSH does not issue standards. It issues recommendations. And its recommendations are based upon levels that are safe and that nobody's going to suffer impaired health. OSHA deals with making sure that the standards are feasible and that no employee suffers material impairment of health. So there's a different standard involved when OSHA promulgates a standard versus what NIOSH does in a recommendation. And the way that the court ruled on this is what NIOSH does is essentially a recommendation. They're going to come up with a level that's probably more stringent than what OSHA has, because it's a recommendation and it does not have to consider feasibility. NIOSH then forwards its recommendation to the Secretary of Labor, and this is an aid to the Secretary of Labor. But the Secretary of Labor is free to consider other advice. So even though NIOSH in this case had made a recommendation that was lower than what OSHA ultimately promulgated the standard as, the court looked at the different charges that Congress had given NIOSH and OSHA and decided that OSHA did not have to follow the recommendations of NIOSH if it was so inclined not to. And therefore they were free to consider other advice, and the petitioners were not granted on that particular point because NIOSH recommendations did not hold any more weight than other recommendations. The last thing that this case addressed was the question of feasibility. OSHA has to set a standard to the extent feasible. And they delayed this particular standard for 2 years to allow employers to make needed changes for coming into compliance. And the petitioners argue that the Secretary improperly considered economic factors for feasibility. Well, what the court did was they looked at what OSHA requires, and they require safeguards for the health of the employees, and that these safeguards may substantially increase production costs. But, and they quote this, that this is not the same thing as saying that Congress intended to require immediate implementation of all protective measures technologically achievable without regard for their economic impact. A standard that is prohibitively expensive is not feasible. And the way the courts determined this is they went through the legislative history of the OSHA Act. And one of the earlier versions had an amendment put on it by Senator Jake Javits, who at the time represented New York. And the Javits amendment said that the Secretary is expressly required to consider feasibility of proposed standards. Practical considerations can temper prospective measures. And the court said that Congress does not appear to have intended to protect employees by putting their employers out of business, either by requiring protective devices unavailable under existing technology or by making financial viability generally impossible. So the feasibility issue was something that Congress had considered and wanted to make sure that the OSHA Act did not put employers out of business, and OSHA did have to consider the economic feasibility. And the court further said that this qualification is not intended to provide a route of reform, to provide a route for employers to avoid reforms, that standards may be economically feasible, even though they are financially burdensome or adversely affect profits. And if you have a whole sector of businesses and some of them are not making the necessary implementations, it's okay to force the lagging employers out of the business. But you can't shut down an entire sector based upon on a regulation. They can be expensive, but they have to have some degree of economic feasibility. And what this means for OSHA standards that have been promulgated from this time is they have to include a section on economic feasibility. They'll address how much money the implementation of this standard is going to cost, and how much it could potentially save employers. And the reason that it does this is they have to show that that these standards are going to be feasible because Congress directed them to do that, and the courts upheld that they have to do that. So economic feasibility is a test that all standards have to pass. The next case is the Society of Plastics Industry versus OSHA. This is the vinyl chloride case. It was another district court case. It came out in 1975. And this dealt with the issue of scientific evidence, and this is considered to be what's called a technology forcing standard. A little bit about this. Vinyl chloride is a major industry. It has several different components. There are individuals that manufacture the vinyl chloride monomer, or VCM, that individuals that manufacture the polyvinyl chloride, or PCM monomer, and the fabrication products which utilize the polyvinyl chloride resins, or PVC resins, which are used in a wide variety of products. At the time of the standard, the manufacturers of vinyl chloride monomer were primarily Shell, Dow, and Goodrich. They did 50% of the production of 5.2 billion pounds a year in the U.S. There were 1,500 workers exposed. Most of these were in open-air facilities, primarily in the South. Goodrich was by far the largest producer, about 20% of the 5.4 billion pounds a year. But there were 21 companies that were involved in the manufacture, and approximately 5,000 for the PVC, and these were not in open-air facilities. And then there are fabricators of products which utilize the PVC resins. These are all over the place. Thousands of workers. You find them in pipes, conduits, wire, furniture, and you may find some residual vinyl chloride monomer escaping during heating in the fabrication industry. Well, there are some health effects associated with vinyl chloride monomer exposure. In 1949, the Soviet Union found liver damage in 15 out of 48 workers that were studied. In 1959, 10 years later, Dow Chemical reported that rat and rabbit liver toxicity occurred at 100 parts per million. And they recommended in 1961 that there'd be 50 part per million exposure based upon the rabbit studies, but the industry stayed at 500 part per million. Then more studies were reporting health effects. 1967, there was a report on softening of fingertips and bones. And then the Manufacturing Chemicals Association, which is MCA, in 1970, recommended a ceiling level of 50 part per million for vinyl chloride monomer. Then in 1970, a report came out that there was cancer associated with exposure in rodents. And, quote, no implications to human pathology can be extrapolated from the experimental model reported in the paper, however. In 1971 and 72, the Manufacturing Chemicals Association enlisted 17 companies to finance research, epidemiology research on vinyl chloride monomer. And in 1973, there was a paper that indicated kidney and liver cancer in rodents at 250 part per million. And this was not revealed to NIOSH for about 6 months. Then some interesting things happened. In Louisville, Kentucky, a plant physician by the name of J.L. Creech found 3 of his patients in a 3-year period developed a rare and unusual cancer called angiosarcoma. This is a type of cancer that appears maybe in 1 in 50,000 patients. And a physician may see 1 case of angiosarcoma in his lifetime, and to see 3 in a very short period of time made him suspect that there was something that these patients had in common. And they did have something in common. They all worked at the same place. And he started a more thorough investigation that they were exposed to a chemical and found they were all exposed to vinyl chloride. He reported this to NIOSH in January of 1974. And by the time OSHA ultimately issued a standard, 13 deaths had been recorded from exposure to vinyl chloride from angiosarcoma. Just a little timeline on how this happened. Today, it takes 2 to 3 presidential administrations to get an OSHA standard promulgated. But back in the early days of OSHA, things went a lot more rapidly. And in this particular case, things went really fast. In April of 1974, the Assistant Secretary of Labor promulgated an Emergency Temporary Standard, or ETS, of 50 part per million. A few days later, cancer was reported at that level. And on May 10th, a month later, OSHA issued a notice of permanent proposed permanent rulemaking, lowering it to 1 part per million, which at the time was considered to be a non-detectable level. They started the hearings later that month. They were held in June and July over the summer of 1974. They received comments up until September of 1974. On October 1st of 1974, the final standard was promulgated and it became effective on January 1st of 1975. So this was really a lightning fast time period to have a chemical go through the 6B process really in less than a year. And again, today it generally takes 10 to 15 years to get one chemical through this particular process. But in the 1970s, things went a lot faster. Well, of course, once they have a new standard out, they're going to end up in court and got sued, and that's what happened here. The Chemical Manufacturers and Plastics Institute sued them, and what they said was that available scientific and medical evidence does not establish that the 1 part per million exposure level is required by health or safety considerations. And the courts didn't agree. They said that the Secretary had the duty to protect the working man, even at the frontiers of scientific knowledge. The petitioners said that no expert testimony was provided that gave a safe level of vinyl chloride exposure. And because no one gave a safe level, the fact that 50 part per million was found in animals and a reduction from 50 part per million to 1 part per million is what the courts consider to be a small margin of safety. I'm a board-certified toxicologist. If you ask me what's a safe level of any carcinogen, I'm going to tell you 0, because potentially one molecule of any carcinogen can bind to one strand of DNA, initiate the cell, and start the chain of events that ultimately results in cancer. So you're not going to find an expert that says this level is safe. And so when the Secretary came up with a standard of 1 part per million, again, which at the time was considered undetectable, the court said this is a small margin of safety, and I as a toxicologist would have to agree with this. And the court agreed that the Secretary acted properly in extrapolating from mouse to man by choosing to reduce the permissible level to the lowest detectable one. So that one issue was resolved. And the second issue that the petitioners had was that the Secretary breached his statutory mandate to ensure that the standard selected is a feasible one. Now, we addressed the feasibility issue on the last case with asbestos, dealing with economic feasibility. This was dealing with economic and technical feasibility. And what industry said was that they would never reach part per million. Production cost would soar at the non-detectable level. And although the Secretary acknowledged this, he said labor groups suggest that such a level is, quote, attainable. What the court said is that the petitioners need more faith in their own technological potentialities. They further said the Secretary is not restricted by the status quo. He may raise standards which require improvements in existing technologies or which require the development of new technology, and he is not limited to issuing standards based solely on devices already fully developed. So this was considered to be a technology forcing standard. Now, once OSHA had done this with vinyl chloride, it was flexing its muscle a little bit on the next case, which was the American Iron and Steel Institute versus OSHA. And this is another circuit court decision, and this dealt with COCUF and admission standards, and this gave the limits of technology forcing. They had already forced some technology with the vinyl chloride standard in terms of feasibility, but now OSHA went a little bit further, and we'll see what happens in court on this case. What OSHA did was promulgate a standard on coke emissions due to leukemia incidents in workers. And the Secretary's standard required that after the implementation of all required controls, the PEL had not been met by a date, then, quote, employers shall research, develop, and implement any other engineering and work practice controls necessary to reduce exposure to or below the permissible exposure limit. So what this did was give the burden of the researching the type of controls on the industry. Well, the petitioners said they agree that standards may require an improvement in existing technology or the development of new technology, but their claim was that OSHA does not authorize unlimited research and development, that technology forcing is limited to what looms on today's horizon. And the court agreed with the petitioners in this case and said the development, because what they used the portion of the OSHA Act which said development of standards under this subsection shall be based upon research, demonstrations, experiments, and such other information as may be appropriate. Therefore, the Secretary can consider the latest scientific data and technology that looms on today's horizon, but the Secretary cannot require unlimited research and development by the employer. Note, this case held the technology forcing authority of the vinyl chloride monomer case, but it slapped the agency's hand and said you can't make an employer go out and do unlimited research and development to comply with the standard that you came up. So this is where OSHA sort of got put in its place a little bit by the courts. They were feeling fairly strong after the vinyl chloride case, but this put some limits on how far they could actually go. The last case I wanted to discuss is the Industrial Union Department versus the American Petroleum Institute. This was the Supreme Court's first review of an OSHA standard. OSHA came about in 1970. It took 10 years before an OSHA standard was reviewed by the Supreme Court. This was the benzene case, and it came up with a significant risk requirement, and that's one of the reasons that it's such an important decision by the Supreme Court. In the benzene case, what occurred is that the Secretary of Labor reduced the benzene standard from 10 part per million to 1 part per million, and this was set at the lowest technically feasible level, basically the non-detectable level as had been done in vinyl chloride. And the Fifth Circuit Court held the regulation invalid. So the Fifth Circuit Court vacated this, OSHA appealed, it ended up in the Supreme Court. But the ruling of the Fifth Circuit Court said that OSHA exceeded its standard-setting authority because, first of all, it ignored Section 3.8 of the OSHA Act, which says that they first have to show that the benzene exposure was necessary and appropriate to provide safe or healthful employment. So the new standard had to show that it would provide reasonable, necessary, or appropriate to provide safe or healthy employment. And it's the 6B provision that OSHA cannot adopt standards to create absolutely risk-free workplaces regardless of cost. OSHA had estimated costs of compliance, but the record lacked substantial evidence of benefits, and therefore this was vacated. And again, it was appealed by OSHA to the Supreme Court, and the Supreme Court was ready to review an OSHA standard, and this is the first one that made it. It declined to rule on the cost-benefit question, but it did agree with the Fifth Circuit Court's holding that Section 3.8 requires the Secretary to, quote, find as a threshold matter that the toxic substance in question poses a significant health risk in the workplace, and that the new lower standard is therefore reasonable and necessary to, or appropriate to provide safe or healthy employment. This was a plurality decision, which meant that you had a split decision among the courts. You didn't have a majority ruling. But it was an unusually important case of first impression because, again, this was the first time the Supreme Court had reviewed an OSHA decision. And in this, they reviewed the record with care in this case, and in this opinion, they described the benzene standard, they analyzed the agency's rationale for imposing a 1 part per million exposure limit, they discussed the controlling legal issues, and then they comment briefly on the dermal contact limitation. Just a little bit about benzene. It's a colorless aromatic liquid. In 1976, 11 billion pounds were produced in the U.S., 94% in petroleum and petrochemical industries, and 1 million workers were subject to low-level exposure. I'm dating myself here, but that's about the time frame when I took organic chemistry in college. And when I took organic chemistry in college, we had a big jug of benzene at the end of each lab bench, and at the end of the day, one person was assigned to clean all the glassware that we dirtied up with benzene. So we just open up the jug of benzene and clean out our glassware, and what did we do with the excess benzene? We dumped it down the sink. But that, again, was back in the time frame that all this was occurring in the mid-1970s. So there were a lot of people that were exposed to low-level exposure benzene back in that time frame. Benzene is a hazard. It's an inhalation hazard. If you're exposed to high levels, 20,000 part per million can be fatal. 250 to 500 can cause mild poisoning, and persistent exposure at as low as 40 part per million can lead to blood-forming diseases such as aplastic anemia. A little bit on the timeline. It was first thought to be involved with the development of leukemia in 1928. The state of Massachusetts came up with an exposure limit of 35 part per million back in the 40s. ANSI adopted a 10 part per million exposure limit or 50 part per million ceiling in 1969. OSHA adopted the ANSI standard when it set up the PELs initially, and NIOSH recommended that the standard be set as low as reasonably possible in 1976. Because of some of the information on carcinogenicity, OSHA issued an emergency temporary standard of 1 part per million in May of 1977. This was vacated due to a restraining order, and in 1978, OSHA issued the final 1 part per million standard. So the issue in this particular case in front of the Supreme Court was this. Was the Court of Appeals correct in refusing to enforce the 1 part per million exposure limit on the ground that it was not supported by appropriate findings? And what the problem was that OSHA showed effects at 10 part per million. But what it did not do is estimate any risk at less than 10 part per million. And they based the risk on certain assumptions, but not on any type of a quantitative assessment. What assumptions did they base it on? They based it on that benzene is a human carcinogen, and that industry failed to prove a safe threshold existed for the carcinogenic effects of benzene. And OSHA assumed that any level above 0 represents some increased risk of cancer, i.e. the one-hit model. And that's what I was talking about with vinyl chloride. If you have one molecule of a carcinogen and it hits one strand of DNA, it could potentially produce cancer. And this is the assumption that OSHA was using to lower the exposure limit to essentially the non-detection level. And OSHA said that Section 6b-5 required that the standard be set at the level which has been demonstrated to be safe or at the lowest level feasible, and some benefits were likely to result from reducing the exposure limit from 10 part per million to 1 part per million. And although this is logical and makes sense, it was not based on any actual evidence. Well, what were the controlling legal issues? What the Supreme Court did is look at the relationship between Section 3.8 and Section 6b-5 of the OSHA Act. And you have a copy of the OSHA Act. You can look through this, but the important points are that Section 3.8 says that standards have to be reasonably necessary and appropriate to provide safe or healthy employment. And Section 6b-5 says standards set the standards which most adequately assures, to the extent feasible, on the basis of the best available evidence, that no employee will suffer material impairment of health or of functional capacity. And what this means is that Section 3.8 requires the Secretary, before issuing the standard, to determine if it's reasonably necessary or appropriate to remedy a significant risk of material impairment of health. And the second part is if a threshold determination shows that such a risk exists, then 6b-5 requires the selection of the most protective standard consistent with economic and technological feasibility. So they first of all have to show that a risk exists, and once they establish that setting the standard then is going to be protective of that risk and setting at the level which is the most protective, consistent with economic and technical considerations. Now the court went back to the OSHA Act, its legislative history, and made the argument that safe is not risk-free. This is a quote from the Supreme Court decision. We think it is clear that the statute was not designed to require employers to provide absolutely risk-free workplaces whenever it is technologically feasible to do so, so long as the cost is not great enough to destroy an entire industry. Rather, both the language and structure of the Act, as well as its legislative history, indicate that it was intended to require the elimination, as far as feasible, of significant risks of harm. What did the legislative history say? Well, what they found is that one of the earlier versions of the OSHA Act said, the Secretary, in promulgating standards under this subsection, shall set the standard which most adequately assure and feasibly assures, on the basis of the best available evidence, that no employee will suffer, and I have this underlined, any impairment of health or functional capacity or diminished life expectancy, etc., etc. Now, the important point is that word any. And again, this was one of the earlier versions of the bill that did not make it through Congress. And it was the word any was changed to material by what was called the Dominic Amendment. And this is because on the floor of the Senate, Senator Dominic questioned the wisdom of this provision, stating, how in the world are we ever going to live up to that? What are we going to do about a place in Florida where mosquitoes are getting at the employee? Perish the thought that there may be mosquitoes in Florida, but there are black flies in Minnesota and Wisconsin. Are we going to say that if employees get bitten by those for the rest of their lives, they will not have been done any harm at all? Probably they will not be. But do we know? So I'm going to back up a minute on that. So oops, going the wrong direction. Sorry about that. Here we are. So this word any was changed to material. Will not suffer material impairment of health based upon Dominic's argument on the floor of the Senate, because something like a mosquito bite would be an impairment of health. And the act was then not designed to cover things that are fairly trivial, but things that have an element of seriousness involved in that. And therefore that word any was changed to material based upon this argument of Senator Dominic, and that one word was very helpful in getting the OSHA Act passed. So ultimately, the agency is responsible to determine what it considers to be a significant risk. And the court gave the agency some guidelines, that some risks are plainly acceptable and others are plainly unacceptable. For example, if the odds are 1 in a billion that a person will die from cancer by taking a drink of chlorinated water, that risk clearly could not be considered significant. Alternatively, if the odds are 1 in 1,000 that regular inhalation of gasoline vapors that are 2% benzene will be fatal, a reasonable person might well consider that risk significant. So the court said that the agency had to develop some kind of a methodology to quantify risks. That they had to show, in this case, that if an exposure of 10 part per million is problematic, that an exposure of 1 part per million would be more protective based upon actual data. And this gave rise to the whole risk assessment process. The whole field of risk assessment was born from the Supreme Court decision, which instructed agencies to quantitatively come up with what the risks of exposures are and how that risk can be reduced by the new standard based upon somewhere between 1 in a billion and 1 in 1,000. So they didn't give a lot of direction, but they basically said you have to come up with some quantitative means of establishing your standards so that the odds are somewhat less than 1 in 1,000, but between 1 in 1,000 and 1 in a billion. So the agency does not have an obligation to find that a significant risk is present before it can characterize a place of employment as unsafe. And second, OSHA is not required to support its findings of significant risk with anything approaching scientific certainty. Again, you've got this range of 1 in 1,000 to 1 in a billion. But as long as they are supported by a body of reputable scientific thought, the agency is free to use conservative assumptions in interpreting the data with respect to carcinogens, risking error on the side of overprotection rather than unprotection. And again, this was the birth of the field of risk assessment. A couple years later, in 1983 or 1984, the National Academy of Sciences came up with the Red Book, which gave instructions on the whole risk assessment field that is used by all federal agencies now in terms of when they promulgate regulations to utilize the risk assessment process. And it came from this particular decision, which was, again, a very, very important decision. And it was the first time that an OSHA regulation had been reviewed by the Supreme Court. Again, it was a plurality decision, meaning that there were people who were in dissent from the decision, and the dissent wrote the following, that the plurality ignores the plain meaning of the OSHA Act of 1970 in order to bring the authority of the Secretary of Labor in line with the plurality's own views of proper regulatory policy. The unfortunate consequence is that the federal government's effort to protect American workers from cancer and other crippling diseases may be substantially impaired. So the important part of this decision ultimately was the birth of the risk assessment process. I've provided links to all of these court cases on Canvas. I'd encourage you to read through those. I've sort of highlighted what the effect of these court cases have had on what the agency ultimately has to do. And you'll see that if you read through a preamble of an OSHA regulation. They will cover feasibility, they'll look at economic, they'll look at technical feasibility, they'll do a risk assessment, and they'll provide methodology to show that a risk exists. And by promulgating this standard, you can reduce this risk quantitatively by this amount. So these four cases have been extremely important in shaping the agency's regulatory policy process.